Hey there, everybody. I'm Larry Vernaglia from Foley and Lardner, and for those of you who are on the left side of the room who maybe have your view blocked because of this podium, feel free. There's plenty of seats right up front if you would like to just move. Jennifer and I thought it'd be a little more conducive to a conversation to stay seated, and we encourage you all to ask questions and raise your hand, and we might not see you too well because of the lights, but feel free to shout out if you have things you want to talk about along the way. So thank you, Sharia, and to MiHIN for inviting us here today. Jennifer and I have a few remarks on fraud and abuse issues in the health IT and EHR space. It's a pretty broad topic. We picked a few topics that we thought would be of interest to you. By way of background, I am a healthcare regulatory lawyer and principally representing health systems and hospitals for about 25 years, and have spent a lot of my work in this arena. With me is Jennifer Belveal, who's a white-collar litigator and healthcare fraud and enforcement expert here in our Detroit office. I can let you offer a couple more words of yourself.
Sure. I as well have been practicing for more than 20 years, and I do primarily healthcare fraud and enforcement compliance issues, although I also do compliance and enforcement issues in other space. Sometimes that tends to trickle into civil litigation as well. Oftentimes they have more of a fraud focus, but not always. Hopefully what we'll be reviewing with you here today are some issues that you can take back and really use to assess your own risk within your organizations and identify those things that perhaps you should be paying attention to under the current state of enforcement affairs.
We're also working on a top 10 David Letterman style list of top 10 compliance issues relating to EHRs for the Association for Corporate Counsel. So if you're a member of the Health Law Committee, you should receive that naturally. If you're not, leave us your business card and we'll be happy to send it to you. So with that, let's kick it off. Where's our clicker?
So we have divided today's presentation roughly in half. I'm going to start off by talking about some general enforcement activities that have been taking place in the last year or so, and then Larry's going to drill down into one particular area. At any point, though, we may both have some comments. You get two lawyers together, and somebody's always got something to say. And please, this should be interactive. We do have time at the end for Q&A, but if you've got a question as we go along, please feel free to let us know. As you probably know, healthcare fraud continues to be a top priority for the Department of Justice. A significant portion of the federal law enforcement budget is focused on healthcare fraud. And in fact, for this year, the healthcare fraud enforcement budget increased. The government itself reports a positive return on investment, meaning that the government believes that for every dollar spent on healthcare fraud enforcement, the government makes between $1 and $5 on that return. And so you can see why, even though there's always budgeting fights every year about how enforcement dollars are spent, they've got a pretty good argument that they're making that healthcare fraud is the place to invest the money for enforcement.
So you're not seeing any lack of priority due to the Trump administration and change of personnel?
No. In fact, while it is true, in fact, I think the statistic just came out last week. I saw that prosecutions overall on the federal level are down over the last year compared to prior periods, and in fact have been decreasing a little bit the last, I think, 3 to 5 years. The healthcare fraud space is actually continuing to be steady, if not growing a little bit. And the healthcare fraud the Medicare fraud strike force actually reported for last year, which is the last year for which we have full records, that it was a record year for them, both in terms of the number of enforcement actions and financial recovery. HHS, DOJ claimed that they recovered $2.6 billion in healthcare fraud in 2017 alone. So while overall, you're right, under the current political environment, you're starting to see perhaps less federal enforcement activity, not necessarily the case in the healthcare space. So in February of this year, the Bipartisan Budget Act actually, in addition to increasing the budget for federal healthcare enforcement issues, also increased criminal and civil penalties associated with some of the enforcement statutes. In fact, the anti-kickback statute, the civil monetary penalties law, and the Stark law all saw increases in the penalties. That's something that I don't know how well it was publicized, but again goes to show you that the government is very fond on getting a good return on its dollar for its enforcement efforts, and this kind of ensures that that happens. The other major development here that we've seen trending, but certainly in the last year, are that individuals are being charged and judges are actually imposing lengthy prison sentences. Not too long ago, when there was some sort of fraud in the healthcare space, I think it was assumed that no individual would actually be penalized, and instead they were more on the order of corporate penalties. But under the Yates memo, and we've seen this play out, I referenced here the Tenet case, Tenet Healthcare, as you probably heard, there was a former senior VP who was charged after the corporation actually settled, I believe it was a $400 million kickback case. And in the past, as I said, I think the focus was once the money was paid, everybody kind of moved on. The corporation may have some sort of continuing enforcement or compliance obligations, but individuals were left alone. That's not the case anymore. And therefore, within your own organizations, you might get a little more attention from the top on healthcare fraud enforcement activities.
Let me add to that, Jennifer, is, we often think about this Yates concept that it relates exclusively to the enforcement authorities choosing to chase an individual after in concept of a case. And we do see this. In fact, we see attorneys from the Department of Justice being open about the fact that they wouldn't have charged this person but for the emphasis from the Yates memo. But for organizations internally, we think that there is an element of this that you can take into account on internal investigations, particularly if you're doing a self-disclosure to the OIG. So we're now strongly recommending that corrective action plans have specific targeted individuals who are responsible at the root cause of a problem. The discipline there be much more explicitly identified to sort of do a baby Yates in the context of your own internal activities.
Absolutely. I would say that that type of pointing out or singling out of culpable individuals is highly encouraged by government enforcement agencies, particularly in the healthcare context, but almost every internal investigation that I work on these days, you've now got to be starting from day one about whether or not someone's going to be thrown under the bus at the end of things, and if so, who those individuals are going to be, because the government is expecting that to happen, which is a big change in how those investigations are run. So on top of all this negative news that I've been talking about, there's actually some good news that's buried in the enforcement world. As we all know from the Escobar case, the Supreme Court recognized the implied certification theory for False Claims Act cases, but we're beginning to see how the Escobar case is being played out, and we're seeing that most courts are imposing some sort of materiality standard, meaning that not all violations of underlying rules or standards or laws and requirements that are required for part of the, or are a basis perhaps for submission for payment, are held to be material enough by the courts to substantiate a False Claims Act claim. And in fact, on a very good note for organizations, courts, judges in particular, seem to be more apt to dismiss False Claims Act at an early stage when there is no materiality being shown. So that's some good news coming out of Escobar. I know it created a lot of anxiety because it was a new theory that was recognized, but it's actually playing out in not such a bad way for healthcare institutions.
Jennifer, where do you think the materiality standard will end? Do you think it starts and stops in the implied false certification cases, or do you think that we should be expecting to see it extended into other areas where there's an explicit violation of an underlying immaterial regulatory requirement? or in an overpayment context where the overpayment is triggered by the violation of an immaterial regulatory requirement, and then the reverse false claims theory, for example, takes effect. Have you given any thought to that?
I think it's a very good question. No one has a crystal ball to know for sure where the materiality standard will end. However, I think it's a very good practice to attempt to incorporate it into everything that we're doing on the compliance, or I should say defensive enforcement actions. It doesn't mean that it's going to win the day, but oftentimes a lot of these cases aren't making it to the courts. Instead, we're sitting across from regulators arguing perhaps why penalties either shouldn't be imposed or should be imposed at some minimal level, and materiality is often key. If it does rise to the level of where you're sitting across from a prosecutor, then of course I'm always arguing it's not material enough to be charged. So I think it permeates everywhere, and I think Escobar has now opened the door to legitimize more of those types of arguments. Other good news is the new policy that was just announced last month. This was Rod Rosenstein's memo that came out that requires now the coordination of corporate resolution penalties. What exactly does that mean? The government has announced that rather than having multiple agencies go after the same conduct as we've seen in the past, instead they say that they're going to coordinate and conserve resources. Makes a lot of sense for us taxpayers anyway, who are saying, why are you spending my money to go after the same conduct? And it certainly helps those institutions who are trying to address problems. Multi-war fronts are often very difficult. The memo actually also notes, buried deep within it, that there will be some coordination as well with some of the foreign law enforcement agencies. It's difficult to know yet exactly how that will be come into play, but there's actually good news on both of those fronts in coordination of penalties. So what do we know specifically about how the government is spending its healthcare fraud budget? I think perhaps one of the biggest keys is that the government is now officially using data analytics to identify its enforcement priorities. In fact, earlier this year, the fraud section of DOJ announced the launch of its healthcare fraud unit's data analytics team. There's no doubt, for those of you who've been in the field, you've probably seen this. DOJ has probably always used analytics, at least in recent history on some level, but now they have an entire team dedicated to using the data to find out where they should go after people to enforce. This allows DOJ to easily identify participants in red flag areas, which I'll tell you about in just a moment. And it also helps DOJ identify outliers. Those particularly high or unusual use of billing codes, for example, can easily be determined now by data analytics. So I would say the government's getting smarter now in going after and targeting particular enforcement areas. So what are those healthcare red flags that I just mentioned that I think the government is really targeting with its data analytics?
You're not going to say opioid again, are you?
Unfortunately, I have to say it, and I'll say it first so we can kind of get it out of the way and move on, because everybody's tired probably of hearing about the opioid epidemic, and I don't see that in a derogatory word, but you'd probably have to be living under a rock to some degree not to know that that is a current enforcement priority for the federal government, announced by AG Jeff Sessions last August. Essentially, of course, companies that sell, distribute, or prescribe should expect an extra layer of scrutiny. And I will say that since this extra enforcement priority or enforcement priority was identified in August of last year, most of the attention has been on individuals in smaller groups, smaller organizations. But large organizations are still at risk. And while they may have different problems than perhaps individuals involved in conspiracies, large organizations have high risk if they do not have a strong compliance program, because the government is really expecting large institutions to step up and help them enforce what they think is a very difficult area for for those individuals, perhaps, providers who are involved in the conspiracy. So you're not out of the woods just because you happen to be a large organization. The second healthcare red flag these days is DME and home healthcare. These are a continuing hotbed for enforcement. This has been a traditionally hot area for the last few years, and it has not changed. Perhaps the government has broadened its scope a little bit more when looking at providers associated with DME and home healthcare. What I would call the traditional earmarks of fraud are the areas that they're focusing on. So kickbacks, medically unnecessary services, services not rendered, garden variety upcoding, billing for unqualified workers, robo-siding, or situations where providers do not actually physically see a patient. In some ways, as I said, this is not new, but the government is really focusing on the substantive areas of DME and home health care as it has previously, but branching out perhaps into these other areas. And the final healthcare red flag area is electronic health records, or EHR. As you probably heard, back in 2009, there were $19 billion in federal funds earmarked for EHR incentive programs. And last summer, the government put people on notice that they recognized those funds in the incentive programs were oftentimes being abused. And a good example of that is the ECW case that Larry is going to talk about. But as a result, whenever there's money, the government seems not far behind looking into things, and this is a perfect example of the government doing that.
That's a great tee up for the second half of our presentation, Jennifer. Thank you. And in fact, there are a number of issues I mentioned before that we're working on the top 10 compliance issues driven by EHR implementation issues. And if you think about it, you go back to Jennifer's slide 7 here, how many of these particular red flags may be triggered by thoughtless issues relating to EHR or EMR technologies, how they're implemented, how they're rolled out, how problems may arise yet not be corrected. And what we believe is that the compliance efforts around these things have been we're a little late to the game. The compliance officers weren't sitting at the table for a lot of the early discussions with Epic when it was invented or rolled out into a particular system or what have you. And so they're playing a little catch up. The issues that Jennifer closed with relating to where there's new money the OIG is interested is certainly not new. If you look at the hospital compliance guidance and all the other ones, all the incentive payments, supplemental payments, extra payments are areas of risk and enforcement and compliance attention needs to be paid to them. So it's inevitable, I think, that there would be something out of the meaningful use and EHR incentive payments. And I think ECW is one of the more interesting ones that I want to talk about. I know that this is a room full of folks who are very knowledgeable on health IT issues, so we won't spend too much time on the basics, but it's important to at least have those basics, which is that there is, as a result of changes in the law, starting with the HITECH Act, there are incentive payments, there have been incentive payments available to eligible professionals, critical access hospitals, and other eligible hospitals if they could become meaningful users. You in the room, everybody has heard that term. Many of you are power users on it. But the three components that the statute looked at were the use of certified EHR in a meaningful manner, so maybe some of the topics that Bradley was covering relating to e-prescribing would trigger that. Use of certified EHR for elective quality reporting and to submit quality data. But the certified EHR element of it was a precondition. That was sort of a starting point. Probably beyond the scope of this discussion, but with MACRA, many of the changes around meaningful use dollars are going to roll into one of the four components of MIPS, and I have some material on that for you in a little while. But the meaningful use dollars were big money. It was, $44,000, $43,000 for Medicare, $63,000 for Medicaid, and $540,000 providers got this money. So to your point, Jennifer, the money's out there, and there were a lot of people now who are curious about whether it was spent properly. OIG thinks a lot of it was not spent properly, is to steal my own thunder, I think. The EClinicalWorks settlement was an interesting one. It was only about a year ago, almost to the day. But EClinicalWorks, which is a EHR package principally used in smaller organizations, I think, physicians' offices, but also some smaller hospitals, paid $155 million to settle their False Claims Act case, all around meaningful use, and some kickback allegations, which were, I think, sidelined. And they entered into a corporate integrity agreement. The allegations, which I've included in broader brush here, perhaps than we need to cover, swirled around whether or not, in getting their certification for their EHR software, ECW lied about what it could do. And the government certainly thought that they did. They misrepresented the capacities of the software, as well as paid some kickbacks, as I mentioned, in exchange for promotion. I thought the kickback case was their weaker argument. The misrepresentation arguments were that they concealed from the certifying body that the software didn't comply with the core certification requirements. Some of the examples of what the government alleged, they're all in the complaint and intervention. And if anyone's interested in a copy of the complaint and intervention, I'm happy to share it with you. Leave me, again, your card and write on the back what you want. But they thought that the software didn't meet the data portability requirements. Patients couldn't get a download of their data, didn't accurately record user actions, so there was no audit log that was reliable. In particular, the ability to pull drug codes was hard-coded in there, according to the allegations. And so, as a result, the EClinicalWorks software didn't meet the certification requirements, and all those users had software that wouldn't have allowed them to be meaningful users. And then those organizations all falsely certified that they were meaningful users. Unknowingly, of course, the end users, the eligible professionals and the hospitals all believed that they had certified EHR technology because ECW told them it was. And in fact, the certification body would have told them it was too. But the theory of the government is that by misrepresenting the ability of the software to meet these requirements, they caused every one of those professionals to submit a false claim, and a caused to be submitted false claim is a false claims case predicate. There's a corporate integrity agreement I mentioned as well that requires ECW to get an independent software quality oversight organization. A little digression: when we've had clients that have had software or health IT problems that resulted in false claims issues, we've often voluntarily, as part of the corrective action plan, implemented such a condition, some sort of external software checker. The ECW also had to notify their customers of any safety-related issues, give them free updates free of charge, allow them to move their data over to another platform without penalties, and they had to have an IRO. The background here, I think, is also important, that the OIG has been saying, as I mentioned before, that they're concerned that there's a lot of improper payment in the EHR incentive environment. They found hundreds of millions of dollars, they believed, of improper Medicare-only payments, not to mention Medicaid, with a number of items in there that are worthy of internal compliance activities. And they recommended to CMS that they go and recover overpayments from the sampled providers, and likely others as well, and CMS said, sure. So that's something to be on the lookout for. Going to jump ahead a little bit to some of the lessons learned and the takeaways from ECW, as well as some of the other risks that we're seeing in there. One of the first stops is that providers aren't safe to just trust that their health IT company has complied with the rules of the game. And I use those terms broadly and vaguely on purpose, because while maybe ECW sent enough message to the EHR community that they would stop falsely certifying that they meet the certification criteria, that's probably true. And probably everybody believes that no one will fake an emissions output on an automotive anymore after one particular company got in trouble over that. But that may not be the case, and providers ought to, at least on a contractual basis, be prepared for that. So some self-audits of the attestation requirements, on my prior slide I mentioned some of the concerns that the OIG raised, is warranted.
Larry?
Yeah.
Have you seen yet the government, perhaps not mandating, but suggesting what those self-audits should look like?
No, we don't see much of that. What we do see, though, is in the context of the Medicare and Medicaid overpayment rules, the government has, the CMS at least, has explicitly instructed the provider community that they must do some proactive compliance checking, and that the failure to do so may be grounds for something like a reckless disregard standard of looking for overpayments. In the OIG's compliance guidances over the past 20 years, they've been explicit that compliance programs are supposed to be scalable, and that therefore audit programs could be scalable as well to the organization. And that's the advice that we've given over time. With respect to self-auditing, though, I think that it would depend on what kind of system you have in place, and certainly as part of an annual risk assessment that your organization has, our thinking is that the health IT risk areas, including some of those red flags that we mentioned in our top 10, ought to be on your risk assessment and therefore subject to a self-audit, at least as you prioritize them strategically and within your cost structure. Where was I? So a few other tips and we have some of our colleagues here who are with us, Chanley Howells here, can talk a little about some of the hardware and software issues relating to EHR, but certainly making sure that your EHRs are updated as much as you can to pick up current and past issues. This is particularly important to me on a coding and billing area, which is a big part of my practice, particularly because I think that coding and billing errors that are driven by EHR programs are easy to catch for some of the reasons you just mentioned, like data analysis, and then they also multiply fast because that one problem that was introduced into the code affects every claim potentially that meets those certain criteria, as opposed to the old bad old days when one doctor, in one medical office in Grand Rapids has charts that don't meet charting requirements. We do think and talk to Chanley about what the vendor agreements need to say and what specific provisions you should be negotiating if you have negotiating power on upgrades, indemnification, and risk sharing. With respect to EHR incentive payments, particularly we're concerned about those providers who shifted from the Medicare to the Medicaid incentive payments. I mentioned before that there's a difference of payment between the two, and if you switched, make sure you didn't get double paid for one particular year. If you had EClinicalWorks as your package, I think that it's worth having a little internal conversation about what you need to do from a risk assessment perspective. ECW has told their customers that the new system, I think as of like December 2016, yeah, there it is, December 2016, is compliant, and that's good, but you want to make sure that you have that package.
If I could just point out, there are many issues that actually stem from the EHR. This EClinicalWorks case highlights some of them, but the number one issue that execs say keeps them up at night certainly permeates or crosses over to EHR, and that is the data breach issues. So, that's a whole nother level that is ingrained now with the use of EHR, and it presents new levels of concern and risks. And the other thing that I will point out, why the EClinicalWorks case involved a vendor that was falsely certifying, and therefore you could say that all of the providers who are using EClinicalWorks were somehow victims in all of this and unknowingly submitting the certification. You also have those problems associated with false certification to begin with, but then what happens, for example, when they get new executive officers, and what are the obligations of those officers when they realize maybe they thought originally, for example, that they were doing the right thing and meeting certification standards, but as more and more guidance has come out, it's clear that maybe they weren't meeting the meaningful use standard? How do you address that? Is there individual culpable liability? I will tell you that I've gotten calls over the last year from CFOs who've joined organizations and realized that there may be a problem with the way in which things are accounted. And as I said, because of the Yates memo, there's also some individual liability concern, and how those monies are reported on financial reports and flow through everything become a huge concern. So this hotbed area in EHR actually has many different facets, not just those highlighted in the EClinicalWorks case.
Well, I'm glad you raised that point, Jennifer, because when this case first hit the press, that was my first concern is, I don't really care what happens to EClinicalWorks, and I'm sorry that they had to pay all that money, but I was worried about what did they do to all their customers who are our clients. And we've been in touch with the folks who are involved with the case, and I believe the DOJ's position is that they see the ECW payment as sort of making them whole for this harm, which is great, and that they're not planning to pursue providers for the meaningful use payments they received innocently and not knowing about the wrongdoing of EClinicalWorks. I believe that they either did or were going to send a letter to their customers about it. If you are an EClinicalWorks customer, I advise you to look carefully at the correspondence you've received and make sure that you have sufficient protections there as well. We believe that the meaningful use issue was corrected by them as of 2016, which is great. But that's sort of the unknown issue with regard to the software problems. Software problems that resulted in billing irregularities or billing issues got pushed out to innocent providers. This is one example, and maybe a one-of-a-kind example, but there's hundreds of other examples where billing software or EHR software resulted in problems for the providers that the providers had no way to know about.
One other thing that I'll note in connection with the EClinicalWorks case, it really is a great teaching example of how the government enforcement is working these days. If you recall, in fact, I think I may have noted it on my last slide, after the ECW case broke, the government actually made a video to kind of warn people about the problems in this area. You can find it online pretty easily, or again, that's one of those things you want to leave us your card. I'll certainly give you a link to the video. But not only is the government now involved in data analytics, but they're making their own and producing their own videos as instruction to the public. And I think the lesson there to be learned is the government, as Larry said, seems to be giving those innocent folks who were perhaps defrauded by this issue a free pass, but they've also told the world, learn your lesson now, because you're not necessarily going to be given a free pass in the future. And so it would behoove you, in connection with your regular compliance programs, audits, to go and look at that type of guidance, because the government's really taking different measures now than it previously has to get the word out.
Good point. And one of the things that we've seen providers in similar situations do before was rat out the bad actor vendor that caused them to have this problem, present themselves as a victim. We've brought entire cases to U.S. attorneys' offices and said, this is what the vendor did, this is how it affected this provider, we'll help you get them. And they are often grateful when you can present a case like that, which can turn criminal rather than civil. The civil folks don't get all excited about it. They actually will thank the client, and then those providers end up having to pay anything because they were the victim who was treated poorly.
So one question I do have, Larry, is are you seeing from your clients on the transactional side those dollars that we talked about early on being dedicated in this incentive area to drying up, or what's the current status of the incentives?
They're going to get rolled into the whole new MACRA payment model. So most of you know that Medicare is looking for a way to have more risks and rewards in payment. And so the ability to be a meaningful user will become one of those four pillars of the MIPS, the Medicare Incentive Payment Program, that will result in a 25% impact. And that impact will result in, that those MIP scores will result in payment reductions to providers who can't make the meaningful use attestations. There is a hardship exception process which is available through CMS if you can't afford it or if it's too difficult to become to meet those criteria. But ultimately, not only are those payment reductions going to go into effect, they're going to be big, and the delta between the winners and the losers is going to be 10, maybe 20%. And if you think about the margins that most of our clients are operating under now, if you have a 10 to 20% swing in your payments, that's the difference between operating in the black and operating in the red. So they're changing behavior through reimbursement policy for sure. So folks, we have reserved a little time at the end of our remarks for any Q&A or questions that you might have. Perhaps somebody would want to take one of these mics out into the room and go Phil Donahue style on us, if there are questions.
I see a hand back here.
Sure. And if you don't have does she have a mic for her? Great.
Okay. So the government, the ONC, charged CCHIT and paid CCHIT and its contractors like the Drummond Group to certify various vendors. So I was curious how ECW, if it came out in the discovery, how ECW was able to fool the certifiers and if any liability went back to those groups.
No, I don't believe it did. I don't believe that's a good question. A lot of the misrepresentations, according to the complaint anyway, and I haven't dug into discovery, but a lot of the complaint implies that many of the things were simply attested to by the vendor. Other elements were done through sneaky hard coding technologies. So, for example, they would hard code in specific drugs in a drug sampling methodology, so that if you tested it, they would always come out the right ones, rather than pull all the drugs that the patients were prescribed. That one looked pretty intentional to me, as opposed to just maybe, for example, on the audit log, that maybe the audit log didn't work as well as it should have, which is kind of how I had read it. So if you believe the allegations in the complaint, and obviously they're advocacy, it's an advocacy piece, there was a combination of outright deception and deceptive programming and some false certifications. And I do not believe that the accrediting bodies faced any heat for it, but if there's anyone in the room who knows differently, I'm eager to be corrected. Other questions?
I'll just add to that. It's a very good question because there are probably other software providers that are more in a gray area, and the question becomes, where is the liability going to lie when those situations come up? So I think it's a great question, but according to my understanding of the facts as well in the ECW case, it was much more black and white.
And with respect to those other vendor packages, they always disclaim that. And they say, oh, you providers are responsible for choosing your own code. But it's a system that forces code choice, that makes decisions and hard codes in selection and levels of coding. So while they might have disclaimed stuff and they say, hey, we're, not my job, man, it is their job.
Now you sound like a litigator.
Yeah. Thanks.
I was wondering what you thought about, it was reported that a lot of the EClinicalWorks customers did not take them up on the offer to refund and switch out their medical record. So what does that say for the state of compliance, that people just kind of kept the product and just looked the other way? They didn't pay the price and they just didn't want to go through the hassle.
I think that's a good question, and I'll answer it as a pragmatist. How many of you have work in a hospital or health system that's gone through a health IT upgrade? And did you like it? No. Right. It's hugely disruptive. And I can tell you that even after you've done it for all the right reasons, it takes years to dig out all the cobwebs in the new and the old systems. And my hunch is that it wasn't so much because they didn't care about the fact that the company they did business with did something wrong. I think it was probably because it was just too darn hard to switch again if the system was working in their mind. And it's probably a lot like the emissions standard case, that I used sort of randomly as an example. But the driver of the car doesn't see any impact from an emissions standard violation, as far as I can tell. And probably, with a couple of exceptions, the users didn't care at ECW either, particularly if the systems were supposedly repaired. That's my guess, and maybe I'm just being a Pollyanna for my clients. Other hands, other questions on this or anything else?
So, Helen, that was a great question about CCHIT, and offline I'd be happy to discuss, as a CCHIT physician juror, some stories that are pretty unbelievable. But without incriminating myself or anybody else, I wanted to ask a question. As a physician and clinician in the trenches, one of the things that's striking to me, and a physician who has some awareness around some of these issues, having been a juror and having just enough technical knowledge to be dangerous, one of the striking things is how we often identify problems, including related to these programs, like the ONC related programs. And yet, even as somebody who's testified before the ONC, one of the striking things for me is how people haven't wanted to hear the problems. And so although the problems have often been raised, where they clearly are not meeting the criteria, people have kind of brushed them under the rug. How do people make a difference and really raise these issues when they identify them in a meaningful, in a constructive way, so that it doesn't ultimately get to the point that it did with ECW? How can we help to bend the curve to constructively move the ball forward in a good way?
You want to go first, or shall I?
I'll let you go first on that one.
Okay. So I think what you're asking is a bigger question than just how to raise issues in a healthcare IT implementation. This is really a fundamental issue in healthcare generally. This is issues related to clinical and quality issues, as well as billing, coding, and compliance. And I think that the industry has made tremendous strides in its willingness to hear concerns or complaints raised by employees, physicians, and others. I think that there was definitely a time when the squeaky wheel got fired, and I think that the whistleblower protections are now widely known in organizations, and so in better shape. Is there plenty of room to grow? Absolutely, but I think it's better than it was, 15 years ago. The second way I want to respond to your question is in the notion of, if there's a response, what's that response look like? And I think that the sort of the TQM approach, or the way hospital executives who are trained in lean might look at that, is they're going to be saying, okay, we hear that problem, let's fix it, let's test for it, let's make sure that it's not repeatable. And in those good faith, honest management efforts, they're looking on a fix it going forward basis. And I think that there is still a tremendous amount of lack of awareness of the fact that fixing it going forward is a critical element of it, but the look back is equally important these days. The Continuum case out of New York is a good example of one where somebody had information in an organization about some billing issues that came through state Medicaid dollars, and presented those to the company, but the company didn't take actions to make those refunds. In my view, that failure to do the look back is the one that raises the greatest risk for the organization. Well, I don't know if that's maybe overstating it, because you have to fix these problems as well. So my second way of answering your question is to make sure that in responding to these concerns or complaints, it's not just solution, the forward-looking solution, it's also the retrospective solution. Jennifer, did I buy you enough time to think about a clever answer?
Well, I think I will just offer the enforcement perspective, and that is that usually, orange prison closed talk, and that's why I think going internally within organizations, as Larry mentioned, through the whistleblower type programs are important, not only for the organizations themselves and they're paying more attention, not only because of orange perhaps, but because of the dollars associated with False Claims Act cases, et cetera. So I think that the real place that we're seeing changes within organizations. And secondarily, I'll just note, again, in the interest of how do you minimize risk or liability, those people who are in the know and are in the position to identify, because of their own responsibilities, problems with systems are in fact being charged as making that voice known. So while I hear your frustration about, public efforts and efforts to get the government engaged, and they may not always be, regulators may not be always as interested as we'd like them to be in these issues. I will also tell you that the expectation is that organizations are being responsive.
Let me give one further last word on that one, which is that the people who are the best at getting concerns like that addressed in the clients that I work with aren't doing so in a aggressive way. They're doing so by making other people around them look good for bringing those issues up. And in particular, I found that the best of these sort of gentle whistleblowers are those who are able to get the CEO or the C-suite activated so that it becomes their idea about making the fix. And they've done so by often keying it into the strategic plan of the organization and saying, hey, this problem which I'm bringing to you is a threat to your strategic plan. And if you get behind it, if you set a good tone from the top on this solution set, you're also going to be looking good to the board because you're taking action to solve for the strategic plan. I've seen that happen on a number of occasions. It's highly effective, and everybody walks away feeling better about it. Nobody likes a problem, but it's better than just being the guy who's complaining. I hope those are responsive answers. Other questions? Yeah, we got one over here on the left.
Yeah, you talked about especially in light of the ECW providers conducting a, self-assessment of their vendor capabilities and whatnot. And I could see for a hospital or health system that is sophisticated IT department having the ability to do that, or at least have a fighting chance. But for a small physician practice that doesn't have that sophistication, and they do rely upon the vendor representation relative to certification, do you have any advice for what they should be doing?
Yeah, I do. Two answers. The first answer is that a lot of physician organizations have a donated EHR package from their local hospital. So you're in the same boat. If you're using Community Connect, so is everybody else. And one thing you can legitimately ask your hospital partners to do is to say, are you doing an audit of the Community Connect package, or are you, can you help us do one? And the second answer, which isn't all that great for you perhaps, is that there are a lot of healthcare consultants who can help with a self-assessment like that, and you can usually negotiate a fixed fee to get one, and you get one on, you get what you pay for. There are probably resources available, or if you didn't have the resources to do an external self-audit, I'd be willing to bet that it wouldn't take long to come up with an internal audit protocol to test against some of the core measures for meaningful use of your software package. And I'd be happy to talk with you offline if you're interested.
I will just add to that, even outside of the healthcare industry, we're seeing that the government regulators are charging even small organizations, so similar to the organization we're talking about here, a small group of physicians, with having some responsibility even when they outsource their entire IT function. So I'm actually currently dealing with a data breach issue right now where that has been the case. And when you completely outsource everything, on the one hand, you can say, I relied on them. We didn't have the expertise. That's why I hired the expert. And yet there is some, may not be good news, but there is some recognition from the government that you still can't outsource everything. You can't just give away the keys to the kingdom without having some sort of oversight. So where does it end? You hire a consultant to watch your consultant. I get it. It's not a great answer, but nonetheless, you can't just give it all away. I think, as Larry said, if you're dealing with donated packages or packages that hospitals are using, it does give you some sense of security, but you can't just look the other way.
But I do believe that we've gotten serious brownie points when problems have arisen, and we've had a consultant in there that have done some auditing or self-auditing. In fact, I know we have. Other hands? We can't see any of the hands, by the way, so if we're ignoring you, don't take it personally. And if there are no other questions, then I guess we will take our break.